Today we have Seema Mehta with us from Law Offices of Seema Mehta, who are into EB-5 petitions. So for Mahaa News, we have got a lot of questions that we are going to meet an attorney who is experts into EB-5, and we have got a lot of questions. And this program is going to be mainly about for the petitioners who already applied for EB-5 and waiting for their decisions. Hello, ma'am. How are you?
I'm doing good. How are you?
Good. Ma'am, are you ready to answer, all our viewers' questions who applied for already who applied for EB-5?
Definitely.
Yeah. And to start with, so investing in 956 approved project versus 956 not approved project.
So, in layman terms, in simple terms, 956 applications are sent to the USCIS from projects, from the regional center and their projects, to say that this is a qualified project in the eyes of USCIS, that whatever you are doing complies with what an EB-5 investment requires. So that is a 956 application.
Right.
Can you apply if the 956F is not approved? Yes, definitely you can apply. What is required is that the project files a 956F. Once it is filed, the project is allowed to start taking funding, and the investor is allowed to file his or her I-526E application.
And another question from our viewer: what happens if my project's I-956F approval is denied?
Okay, so suppose you have invested in a project where the 956F is denied. The RI, it is the Reform and Integrity Act of 2022, has given a lot of things where they are protecting the investor. So a good faith investor, meaning someone who is a legitimate investor who has done a good filing, is given up to 6 months to take his money from this particular project, which now has received a 956F denial, and put it into a different project which has a 956F approval, or maybe no approval yet, but a different project. And you do not lose your priority date. That's an important thing to remember.
Right.
What USCIS is saying is, as long as you are a good faith investor, if something goes wrong with your investment, which is not your fault, it is the onus is on the project or the regional center, you can withdraw your funds and put it into a different project without losing your spot in line. Your priority date stays intact.
Okay. Another question: what happens if the denial happens after August 2026? Because once the protection ends for the current investors, because after that the grandfathering is going to start.
Right. So you're talking of the September 30th, 2026 grandfathering date.
Right.
So the grandfathering essentially means that anything that was filed before 30th September 2026 is viewed under the current laws. It is going to be adjudicated under the current laws. That means nothing changes. Even if the 956F is denied after September 30th, 2026, it doesn't matter. The same laws apply. You can withdraw your funds within the 6-month period and invest it in a different place without losing your priority date, which is the key thing. You do not lose your priority date, so your place in line has not gone anywhere.
Yeah, a similar question: can investors switch into another EB-5 approved project while porting their priority date?
Precisely what we just answered, that yes, you withdraw your money and you put it into a different project, you maintain your priority date. You have to inform, of course, you're going to inform USCIS, the Investor Petitions Office, that this has happened and please retain my priority date, and I'm sure your attorneys would be able to do that.
And another question: does the project I-956F have the IOE receipt number?
A 956F receipt does not have IOE receipt numbers. IOE receipt numbers just identify the type of applications. So the 956F applications have an INF receipt number. It begins with an INF followed by 10 digits.
So another question, what is WOM and when WOM should be filed?
So writ of mandamus is what is, a lot of people say WOM, but it's a writ. It is where you file a lawsuit against a government organization trying to tell them to expedite, that they have not done what they have promised. In the current EB-5 arena, a lot of people are filing writs against the government, against the USCIS, saying that they have not adjudicated their I-526s in time or their 485s in time. You asked when should you file it?
And when it's going to be qualified to file for WOM?
Okay, when can you file a writ of mandamus? Generally say, suppose you have invested in a rural project. Now the government has promised you expedited processing for this petition, that the 526 will be approved within say 6 to 12 months. So after 6 months you can make an informed decision, talk to your attorneys whether this is the right time, and you can potentially file a writ of mandamus. Now suppose you have filed for adjustment of status. Your 526 has been approved, your category is current on the visa bulletin. That means a visa is available, but your 485 is not adjudicated. You can definitely file a writ of mandamus after waiting for say 3 to 4 months of your 526E approval. So the 526E approves on day 1. We can wait 3-4 months and then file a writ for the 485.
Okay. And what are all the current timelines for EAD and AP?
Current timelines for EAD and AP, whether you invest in a rural or a high unemployment project or an infrastructure project, the current timelines are 8+ months. I've been telling everyone it is 8 to 11 months of timeline that you will see for an EAD AP. After 11 months is when we can start worrying a little bit and maybe reaching out to USCIS, requesting them to expedite if we have a legitimate reason. Otherwise, USCIS can take up to 14 months also to give EADs.
So these days, what is this combo card? Some people were getting combo cards.
Combo cards is what has historically been how USCIS adjudicates and gives out the approvals. The card is your EAD card, which is your Employment Authorization Approval card. It's a small card with your A number, with your name and the validity dates. So a combo card means that the same card also has your advance parole approval details, meaning at the bottom of the card it will say advance parole, good to travel, permission to travel. So that is a combo card. Same card has your EAD and your AP. Some people will not get a combo card. That happens if you've not applied for both the petitions together, or one of your files got adjudicated, the other one is sitting with a different officer and takes longer. In that case, you get EAD card and then you get a little sheet of paper as your advance parole.
Okay. Another question, ma'am. What are all the current timelines for 485?
485 timelines depend on your 526E. If you've already applied and are waiting for 526E, you have to still wait for the I-526E approval. After the 526E is approved, you can expect your 485 to be adjudicated within about a maximum of 6 months.
Another question, can JCE start the process without I-956 approval?
You mean the commercial enterprise? Can it start its construction or its work or take the money from the investors? Yes, they can. The 956F approval is essentially just saying that the government approves of the way you are creating jobs or the way you are going to do your construction or whatever you are doing.
Another question, ma'am. A guy sent us regarding I-526E. So what happens if my I-526E is denied after the I-956F approval? So can I reappeal for this case?
Definitely. So you must understand that if the 956F is approved and the 526E is denied, the fault lies in your source of funds or your biographics or something about you. So of course you can appeal. If the USCIS has made a mistake, you can appeal, tell them what the mistake is. If you had not submitted some document, you can submit that document and appeal. So yes, definitely. You can also reapply. If you're still on your good non-immigrant status, you can still reapply also.
Another interesting question. Is it possible to get I-526C approval for the investor without the I-956F approval for the project?
Definitely. Very interesting too. Have we seen that? Yes, we've seen that. There is nothing in the law that says that the 526E will not be adjudicated without the 956F approvals. But what we have seen is that the IPO is adjudicating the 526Es after the 956F approval comes through. So as soon as the 956F is approved, suppose I am investing in a project which does not have the 956F approval. As soon as we see the approval, it could be 6 months, 8 months, 10 months, 15 months when the approval comes in. The day the approval comes in, within the next 30 days, you will start seeing adjudications.
Okay. And is 956F and I-526E are linked each other or are they independent?
No, definitely linked. Because your 526E is talking about your source of funds, qualifying you as an investor, and also talking about the project where you are investing. So 956F is all about the project, and it is obviously linked to your application. How good is the project? How is your money going to be used? How are the jobs going to be created? So both the applications matter.
Another viewer, ma'am, his question is about the full funding extension letter. So for investors like me who are still, need to do the full funding, what should be the extension letter look like?
So I think what he or she is asking is that they have done partial funding.
Right.
They were supposed to complete funding for, say, at a certain given date. Suppose they did their funding on 1st of Jan, partially. They did 100,000 on 1st of Jan. Now they were supposed to finish funding, say, by 30th of March. By 30th of March, they did not complete funding. So now they have to go back to their project and get a letter from the project which allows them to fund at a later date. It will be an amendment letter. When people do partial funding, they actually have an agreement, a promissory note between the investor. The investor is giving a promise saying that I will invest by a certain date. Now they've not invested to that date, so now they need another letter where the project says, okay, you can invest by X date. So if it was 30th of March, now the project can say you can invest by October of this year.
Okay. So when the I-956F is not approved yet, the funds are going to be in JCE account or an escrow account?
No, that's not related at all. So 956F approval is just to say that everything with the project is good. That is not stopping the project from taking the investors' funds and using it into the project. The funds are not sitting in the escrow accounts. The project just begins its work.
Another question that relates to project. Initially, my regional center was proposed last year. Since the project has been delayed, the cost of the material, all the project high level application might change because of the inflation and all. So at this point of time, what happens with my I-956F approval standpoint?
No, nothing happens. I don't think 1 year inflation will matter. I don't think 956s are sitting for years together where inflation takes such a big role. But if there is a substantial change, if the project was making 20 homes and now the project thinks we'll only make 15, they can send an amendment to USCIS. I don't think that is a huge thing for an investor to worry about.
Okay. Okay.
Yeah, and then we just talked about money sitting in an escrow account versus going into the project. Of course, all these questions are for the project teams to answer, but it could be that each project can have their own way of dealing with these situations.
Yeah.
I could say that I am not going to start construction till I get my 956F approval. And I could say that no, I am very sure all my documentation is perfect. The way I filed my 956F is an approvable application. I'm going to start. So it could be either way.
Right.
You're in project A, which is keeping the funds in escrow until the 956F is approved, or you're in project B, which is taking the funds and starting the project.
Okay. Okay. Another question. This viewer is asking about his withdrawal situation. If I am unable to arrange funds on time and need to withdraw my I-526C application, what is the reasonable time frame and when can we expect our funds back?
Funds back, of course, again a question that should go to a project. When you sign up with any project, there will be provisions within your agreements, which will be about your 526E denied, if it is denied, if you withdrew, if you did something wrong, if something happens to the project, how will the funds be returned? So of course it is between you and the project. Say today you realize you don't have funds enough to complete your 800,000, you will first you will first file with the IPO and request them to withdraw your 526, and they're very good with it these days. Once you send a letter, they will send you an email or they will update that your application has been withdrawn. The funds is between you and the project. It will be pretty clear with most projects how the funds are returned. I have seen quite a few and the funds have come within a month or so after they have withdrawn their petitions. And then we have also seen where the funds have to remain invested in accordance to the subscription agreement for 5 years. So, it could go depending on where you're investing and what your terms are with the project teams.
Okay. Another question, ma'am. Does EB-5 petitions EAD period is getting shortened?
Yes, it's not getting shorter, it's gone back to the prior timelines. In between, USCIS had agreed to give EADs and APs for a 5-year validity. Now recently they went back to the old one, which was 18 months. So now the combo card that we talked about is going to be for 18 months and every, it will be a cycle. You'll have to file for extension. A renewal.
Another question that relates to travel. So, can I travel to in any country on my EB-5 AP, which is approved, and as we don't have visa appointments till 2027 in India, and can I work on H1B in US, and can I use my AP for travel?
A very interesting twist here. So, AP for travel, 100%. No problem, you travel wherever you want to and you come back, you should have no problems. Now, can you come back and work on your H1B? So, there is a little memo I will share with you and you can share it with your viewers where USCIS has directed and explained how you can take this forward. So, suppose the H1B is approved for a certain time, you are on that time period. And you traveled and you came back and you filed for an H1B extension, you continued working on H1B. You are qualified, a bit of a grey area, but you are qualified to extend your H1B in that situation. Suppose the H1B is ended, right? The H1B is ending and it is not stamped on our passports. We travel and we come back. Now we have to go on to our EADs. Now we cannot extend because we have not maintained our H1B. It's a bit of a grey area. As I said, I will share that memo with you, which will clarify in what conditions you can and in what you cannot.
Another question, can we take a loan on credit cards?
Yes, definitely. You can take cash withdrawal, as we call it, on your credit card. Documentation, of course, is needed.
So, I can see the current wait time for an I-956 approval is 15.5 months. Should I be worried about it?
No, that's just the processing times that any organization takes for any application. So most of the 956Fs that are being filed can take up to this time. This is actually the average time. We have recently seen a few projects that have filed their 956Fs in 2024. In the last quarter, I think October and November, a project or two have just received their approvals. They had filed in October. The projects that had filed in November, December have still not received their approvals.
And another question, the current timeline for 485 is 30 plus months. If this is the case, when will I get my full green card?
No, that current timeline, the processing timelines that you see online when you check on USCIS.gov shows 30 plus months, but that is not related to your 526E petitions. When you invest with regional centers, then after the 526E is approved, in 4 to 6 months, you should get your permanent residency in the current times.
Another question, ma'am. I have done a partial funding for my EB-5 petition. And the remaining funds, I have thought I'll get it on loan, but the loan is not approved. Shall I get it via gift?
So what you're trying to say is when you filed a petition, you had informed USCIS of your source of funds. And in that information, you have stated that you're going to get a loan for the remaining 200,000, and now you're not being able to get that loan.
Right.
In this situation, it is considered a material change.
Right.
You have informed the government of a set process to get your source of your funds, and now you're changing it. So the government considers this as a material change. You can definitely go take a gift or take a different kind of loan or use your savings or sell some stocks or whatever to get your 200,000, but simultaneously, when you file your amendment, when you file a supplement for your full funding, we call it the full funding supplement, at this stage you have to inform your attorney and you've got to make sure that the USCIS understands why you have to make this material change. So that there is a provision where an application can be denied because of a material change. So you have to be cognizant of this fact. And make sure that USCIS understands that you've made a material change and why, and you should have an approvable filing now.
Another interesting question, ma'am. So, I have submitted my documents till the date of investment in the project, and does USCIS ask for my all other documents till my project approval or my I-5 to 6 approval? Is there any chance that USCIS might ask for documents till date?
Generally speaking, your documentation is submitted up until your investment. USCIS IPO does not care for post or really far back. They are only interested in that 800,000. But is it to say that they cannot come back and ask you for some documents? No. I cannot say by experience that we've ever been asked for documents after investment. We've never been asked. But because we are filing adjustment of status also, the service center can come back asking for the tax returns to show your maintaining your H1B or what you've been doing on an EAD. But in the investor petitions arena, I've not seen them asking beyond your investment time frame.
Okay. Another question. My EB-5 petition is in pending and I got a DUI. Should I be worried?
Definitely, DUIs are a cause for concern. You have to inform your attorneys, and then when the DUI is not going to make a difference on the 526E. The DUI is going to make a difference on your adjustment application where you want to become a permanent resident. There, the USCIS wants to know. So if you have a DUI, they are going to send you a request for more evidence if they found something. It is again, they go case by case whether or not they want to ask you If they do, then you're going to submit all the documents related to it. And by and large, I think you should be okay.
Another question, ma'am. This is also very interesting. My EB-5 petition is in pending.
Okay.
Am I good to apply loans, buy houses, cars, whatever that required?
Definitely. Your life is not stopped because you have applied for an EB-5 or applied for an adjustment of status or applied for anything. You are your status quo, whatever your status is. If you are maintaining H1B or if you have your EAD AP, you continue doing things as you were always. You can buy your homes, you are taking your risks, nobody is stopping you to do that.
Another question. My EB-5 petition is in pending and I don't have any other work authorization now. Am I legal to stay back here even after 180 days?
Yes, definitely. That is the most beautiful part of concurrent filing. A lot of people, a lot of people have where the H1B employer has said they are not going to extend your H1B visa. So you have filed, now you have your 485 receipt.
Right.
If concurrently filed, when you file your 526E and 485 along with it, as soon as the 485 is filed, you are okay to stay in the country. You do not accrue any illegal presence. You are not unlawfully present in the country because now you're waiting for your permanent residency. That's the positive part. The negative, until you get your EAD AP, you are not allowed to work if the H1B has expired. The expiration date, from there on, until we get our EAD, you cannot be employed.
Another question, ma'am. My EB-5 petition priority date is in the month of May 2025 and my friend's petition priority date is in June. He got his EAD and AP approved, but I haven't received my EAD and AP, which means he is 1 month early but he
still no EAD AP, and that is because different officers have different workloads. I am doing a petition, as in different attorneys filing your petitions. I might be filing for people with really, really complex source of funds and taking 5 days per petition, whereas the next attorney might have straightforward source of funds. While I finished 1, they finished 3. Right? So similarly, all the officers have different caseloads. They take their time. Some investors' background is faster, some is slower. Some officers have heavier workloads. That's why your petition is waiting. What can you do for it? You just go back to USCIS, you talk to your attorneys, you can write to USCIS. Does not help by and large. You will take your time and get your EAD APs. But if you feel like inquiring, you can.
Okay. Another question, ma'am. My service center is taking longer time when compared with my other petitioners, my friends' service centers.
Again, it is the caseload of the officers. I know I've heard a lot about California being faster or Texas being faster. But again, the way we see it, the timeline remains between 8 to 11 months for all the applicants, be it California, be it Texas Service Center.
Now, finally, so I-956F is taking so long these days. So, should an investor be worried about it?
No. We do get a lot of queries on why the 956F is taking longer, why the EAD is taking longer, why any application is taking longer. So initially after 2022 when we started applying, there were 10 investors, then there were 100, now there are thousands. Initially there were 5 projects, then there were 10, now there are thousands of projects. Now the same number of officers or maybe a few extra officers are dealing with so many more 956 applications. Obviously it is going to take longer. More background checks, of course, more they are doing their due diligence also. They are also looking at the project credibilities. But it is the case loads that have increased. That is why everything is delayed, be it 956F, be it the most common question on EAD APs. The number of applications are much more in these days. should the investor be worried? I get a lot of our own clients who will write to us and say, my EAD AP is not approved. Is it something related to the fact that 956F is not approved? Not at all. Your EAD AP application is free of the 956F application. So no, it is just the caseload with that officer who is looking at your application.
Okay.
Each time we also get a lot of investors who say, my application was reviewed and has now moved to California. Or my application was at California, has now moved to Nebraska. Should I be worried? No. These are also these are all inner mechanisms. USCIS sees that you have less workload, I have more. Half of my applications should move to you. You are sitting in Nebraska, I'm sitting in California. That is how it happens. Should I worry that the 956F is taking longer? Not really. There is nothing to be worried about. The only thing that I can tell my clients who are waiting for the 956F approval is that it doesn't matter. That it is, you have done your due diligence on the project that you have invested in. You are aware of what the documents were as they were submitted because you have signed the subscription documents, you have signed the operations agreement, you've seen a lot of the project documentation. So you are aware that the project documentation is good.
Right.
So you don't have to worry. You don't have to worry about the 956F, whether it got approved in 6 months or it took 16 months. We know our approval will come.
Right.
If we've done our due diligence, if everything was good, as fine. But you should not be sitting on wanting to do your full funding if you are a partial investor. If you had invested 100, 200, 400 and you had promised to do your full investment in 4 more months. Now you've been waiting that, okay, I will invest the full amount
only
when the 956F will be approved. That is not a good strategy at all because the day the 956F will be approved, all these 100, 200, 500, whatever the project had taken, applications will be now ready for adjudication. USCIS is going to see that you had promised a certain date and you did not fund. Immaterial of the fact that we have updated our amendment letters and the project has agreed that you can fund a little later. Immaterial of that, you're going to get a fat RFE. You're going to, or in worse, you're going to get a NOI or a denial saying that you were supposed to fund and you did not. End of story. That will be a bigger stress than this worry about the 956F. That is my biggest worry with my clients who have funded in any project. 956F approved or not approved.
Thank you so much.